My name is Brandy Denier, and I am an attorney with Browse McDowell, an Ohio-based law firm. I am co-presenting today with my partner, Marguerite Zins. Our practices focus on litigation and discovery management and information management. I'm going to start by discussing the duty to preserve and the common law and statutes that define that duty. And then Marguerite will discuss the legal hold process and spoliation claims. The duty to preserve is a common law legal duty to preserve evidence. It arises upon the reasonable anticipation of litigation, which often occurs before a lawsuit is filed. The duty to preserve applies to all parties. However, it is a simpler concept for individuals. For organizations, especially those that typically have a lot of electronic and digital information, complying with the duty to preserve can be a much more complicated process. The quote on this slide is from the fourth published opinion in Zubilacki versus UBS Warburg LLC out of the Southern District of New York. The duty to preserve existed long before this opinion was issued, but the series of discovery opinions that came out of the Zubilacki case were the first to deal in depth with the discovery of electronic information. In today's technology-driven world, electronic and digital information are often relevant to disputes and litigation. However, the duty to preserve applies not only to electronic information, but also to physical evidence, such as paper documents or other objects relevant to the dispute. For example, when a worker is injured while using a machine, his employer is obligated to preserve the machine in its condition at the time of the injury. Or in a dispute stemming from a car collision, the parties are obligated to retain the vehicles that were involved if litigation is reasonably anticipated. More than one injured plaintiff has lost a product liability lawsuit because he or she neglected to preserve the very product that caused his or her injury. The duty to preserve can be broken down into related concepts. First, when does the duty arise? And second, what does the duty encompass? What should be preserved? Third is how should the information be preserved? And that's the part that Marguerite is going to talk about. I will talk about the first two concepts, when the duty arises and what should be preserved. When a party first anticipates litigation, when the duty to preserve arises, is not always clear-cut. The next slide lists events that may trigger the duty to preserve. The duty to preserve undeniably exists once you are served with a complaint. However, the duty may arise earlier when you receive notice of a claim against you. In some situations, it can arise at the time of the actionable event, such as when an airplane or helicopter crashes. The passengers are seriously injured or killed. In most situations, the airline would be immediately aware of the tragic event and would anticipate not only eventual litigation, but also an FAA investigation. If indeed the airline is aware of the event immediately after it occurs, the airline's duty to preserve evidence for the government investigation, as well as information for the anticipated civil lawsuits, arises practically simultaneously with the occurrence of the crash. Now, this is an extreme and rare example. In some situations, the preservation obligation is not so easy to recognize. The decision to file a lawsuit does not happen in an instant. The realization that a lawsuit may be filed may even occur gradually over time. For example, a patient's surgery may appear to have been successful, but complications gradually develop. The patient confers with a different surgeon about his treatment options and learns that his doctor did not follow the standard of care when treating his condition. Over the next several months, he talks about his experience with his therapist and a member of his support group, both who encourage him to file a lawsuit. He discusses the process of filing a medical malpractice action with a friend who once worked for the local court clerk's office. He eventually asks his neighbor, a tax lawyer, for advice and is referred to a medical malpractice attorney. He thinks about his legal options for a few more months before finally making an appointment with the medical malpractice attorney.